for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
SJC-11523, Commonwealth versus Edward Corliss.
Good afternoon, Mr. Nyman. Why don't you take a moment and proceed? Before that, our condolences, Ms. Klenoff, with regard to your loss. So. Okay.
Good afternoon, Mr. Chief Justice, members of the court. I represent Mr. Edward Corliss on appeal. I did not represent him down below. There are 5 issues that I've briefed here, and I apologize for asking to go out of order and perhaps just focus on what I believe are perhaps the stronger issues, starting on page 39, which is the second to last issue, that being the matter of the trial judge, Justice Kottmeyer, limiting the defendant's expert's testimony. I assume that the court's familiar with the facts of the case.
We are, but help us to try to visualize precisely what was allowed in and what she said could not come in.
Okay, the defense expert fused images that came from the security videos from the actual crime itself with a height chart and photographs or video that was taken after the murder, when he was permitted to go inside the store and try to sort of recreate some of the heights, or essentially be able to show the jury that the heights that the defense believed were going to be presented by the Commonwealth relative to parts of the store and the defendant were not accurate. So he fused the security video with his own video and wanted to show that depending on where...
They fused, I'm just side by side, or...
Superimposed, I guess it might be a better word. So essentially when you take the suspect in the store at a few different locations and then match it up with a height chart, what you see is the suspect's height changes depending on the location that the person's in the store. And it really makes the range in height somewhere between, let's say, 5'5" and 5'11". So there's a 6-inch range in the height of the suspect depending on where he is in the store. And that's based...
Is part of the record these fused pictures?
Yes, part of the record is the fused pictures. It's a little confusing. Actually, I give counsel a lot of credit. We talked about this at length earlier today. The video that actually came in as exhibit number 321, and I think SS for identification is the fused videotape, and it doesn't read properly in the transcript, I don't believe, because I think the SS was, I'm sorry, I think 321 was actually a redacted version of SS. So SS shows the entire effort by Michael Garneau, who was the defense expert. At 321 limits it to what Justice Kottmeyer said could come in.
But the judge concluded that this was too confusing and therefore didn't allow it, but certainly allowed all the points to be made that you're making.
And it makes it less confusing when you have something to look at and something to compare it to, first of all. And second of all, it wasn't confusing. It's not confusing. What was a little bit confusing, and what I think Justice Kottmeyer became concerned with, and certainly the defense was concerned with, is that there's a bolt in the wall that's at 61 inches in height. And when you take a look at the suspect walking through the store, the bolt is used as a reference point. And all of a sudden what you see is perhaps somebody who is more the defendant's height than the actual height of the perpetrator at the time of the murder. So that's misleading, or it's confusing. I'm not sure it's misleading, but...
But didn't she allow frames from the video to be put in evidence that so long as they showed the height, but without any person, and certainly without the perpetrator of the crime? I thought that was a way of allowing in some of the video evidence, but without having the potential for showing the person who in fact robbed the
They did, but that's where the confusion really comes in, and that's why the defense should have been.
How is that? I don't understand that. Why is that more confusing? I mean, so that you could actually.
Because
and-
you can't see where the person's height would have been relative to the height chart, so.
But there was testimony from the expert that, to the difficulties in ascertaining the height from the video, right? I mean, so.
That's the point,
Everything
right.
that was wrong with the video, the expert was able to point out.
Right, but you don't have that compared to the height chart, whereas when the Commonwealth puts its video in, you do have it compared with the bolt that's in the wall. And that's what's distorted here.
But-
I don't want to use the word misleading because it's not, but it certainly doesn't give the jury the fair impression. And Justice Kottmeyer, during the colloquy and the argument, when the defense was trying to get this evidence in, made the assumption that the reason that the Commonwealth was referring to the height of the bolt was to give some sort of perspective on the height of the suspect relative to the crime scene.
Let
And
me
she
ask,
said,
was that part of the Commonwealth's case, the video of the robbery?
that was part of their case.
I mean, so it went in, the video went in, so they could see a perpetrator robbing the Tedeschi's.
Right.
And so did different frames go in with the expert? Without the perpetrator?
No, well, they are different frames, yeah, they're different frames because they have the height chart in them, but without the perpetrator. But it's at a
But
different.
they do have the height chart in them.
But it's at a different time. It's taken long after the fact. It's when the defense was permitted to go in and do their reconstruction, and which unfortunately, there've been renovations to the store at the time. So but one thing you have to understand is that Michael Garneau, the expert, said, look, this is all within a half inch or so different from what the scene was like at the time of the murder. So it wasn't that big a deal, and people weren't really focusing on those exact measurements. The defense was actually focusing on, look, you can't make this determination. Here's the range. So don't assume it was Edward Corliss who did this just because of his height relative to the bolt. Now, the Commonwealth...
But he was able to get that in. I mean, that testimony came in.
Yeah,
Yes.
but you know what? Testimony without something to visualize it oftentimes isn't the best. And the Commonwealth did have a videotape where you could visualize Edward Corliss relative to the bolt.
Could you see anything about the face of the person, of the perpetrator, or was it all,
No, I mean,
was
it
it
was
just a question of height? I mean, was there anything else that was identifying with respect to who the perpetrator was?
Well, I mean, no, there were disguises. No, and not that was definitive, no. I think some of the pictures were grainy. I think there were, the individual was disguised at the time, which was a further part of the defendant's case. So no, that wasn't like you take a look at this and no, that's definitely Edward Corliss. So the defense really was trying to make this distinction, and I thought they were doing a pretty good job of it. I'm not really sure why Justice Kottmeyer put such a strict limitation on their ability to put on this evidence when it was in fact really good evidence. And if you read her colloquy, I think it's, or I'm sorry, the discussion to the argument, I think it's the September 22nd testimony, somewhere around page 88 or 90 or 92, she does make a comment, well, I assumed the reason that the Commonwealth was putting this evidence in was to get some sort of a basis for height or a foundation for the height of the perpetrator. And they compare it to that 61-inch, or that bolt that's 61 inches off the ground. And so the defense takes it the next step and say, yeah, we just want to show that's inaccurate based on the camera angles. And that, you know, the camera's coming down from the ceiling in the store, and depending on the angle, there's a distortion as to what a particular person's height's going to be. And it was.
Is there any concern that I won't call it experiment, but what your expert did was scientifically correct? Not so much in a Dalbert sense, but I understand what he was trying to do, but was the judge at all concerned that this was not a correct analysis? I know she said she didn't think it would be useful to the jury. Was that part of her concern, that Well, I don't know how you could make the point that he's trying to make here.
I mean, I think it's a great question. It was something I was trying to read into when I'm looking at this, but the word Delbert or Lanigan never come up. So I think she credited the expert with having the expertise in this particular area that he could do this stuff. I think she accepted what he said was true, that everything we did comes within a half inch of what the original crime scene was like. She essentially said, though, it's misleading. And it wasn't misleading because the defense wasn't going to rely on that and say, this is definitely the height. The other troubling aspect of this, too, and I'm not sure how the court would handle it, but the defense makes his representation in the opening statement that the perpetrator is perhaps closer to 5'11" when Mr. Corliss is a lot shorter. And, of course, that ends up really never coming out during the trial. I would argue in large part because of these limitations. So you kind of
does the record speak as to how tall he is, Mr. Corliss?
Does it speak to, I'm sorry?
How tall he is?
You said he's shorter than 5'11". Does it say what he is?
No, I mean, do you want to know?
So-
I mean,
so
no, the record,
doesn't speak as to what his height actually is.
no, that, I didn't find that in the record, and I was looking for it one more time today. No, it doesn't, I don't think that's mentioned anywhere. Mr.
But
Corliss
the
is
jury obviously would have seen him because he's in the courtroom.
right, and he's well, last time he appears to be under 5'6". He's a relatively short man coming from a short man.
And did the expert provide an opinion as to, based on his analysis, what the height was of the perpetrator?
I think, there were three sort of frames that were used for reference, and two of them, they were given heights, one being 5'5" and one being 5'11". And so that's a significant point, because what the defense is trying to show is, look, if from one camera angle, this individual, the real suspect, is 5'5", and from another camera angle, he's 5'11", we have a real problem with the accuracy or the practical use of these video cameras. I will say, in the Commonwealth's favor, they backed off of any of these representations in their summation. So they didn't start making arguments, which they couldn't have anyway, or couldn't have properly made, about the height of the perpetrator. But and inferentially, when you read the Commonwealth's case, you kind of think, well, perhaps that's where they're going when they look at the height of the bolt and then the height of the suspect compared to the bolt. So, and as I said, properly, the prosecutor stayed away from that in the summation. I'm not sure how you could have raised it, given what the defense ended up proffering anyway.
So just let me see if I know exactly. The expert did offer an opinion and said that based on what I did, based on one camera angle, the perpetrator is 5'5". Another camera angle, the perpetrator would be 5'11", and therefore disregard any inference that you may get from the Commonwealth that based on height from the videotape.
That's perfect. Absolutely correct.
So, but the fact of the matter is, from what you're telling us, 5'5" would not be a poor approximation of what his actual height would have seemed to the jury.
Right.
So it's not as if his opinion said, based on my analysis, it could not have been Mr. Corliss based on his height. He simply said the Commonwealth's evidence as to height is not reliable.
Right, and that's also not where the defense was going with it. They're going, so you understand the point very, very clearly.
So then the next question.
When you say that's not where the defense was going, you mean that they weren't going to, it couldn't be he?
No, they weren't going to say this. Well, right, they weren't going to say, they were going to say this video does not identify a height, and when you have a 6-inch margin of error, you can't all of a sudden turn around and use this bolt in the wall and say, all right, the suspect's only about 4 or 5 inches speculatively taller than that, therefore it must be Edward Corliss.
Can I just tell you, I'm really not understanding how it is that you're arguing he was prejudiced by this.
Well, because you have a video that comes in the Commonwealth's case in chief that shows a bolt in a wall and an individual walking that has a perceived height above the bolt in the wall. Then when the defense is allowed to present its case, it can only use height charts. It can't take this person who's walking and superimpose it as, or fuse it as they use in the transcript against the height charts and say, look, here he's 5'11", here he's 5'5", you can't trust these cameras, and this is why. So it's almost like you're saying, disregard what you saw during the Commonwealth's case in chief, but we can't visually show you why.
We can't visually show you, but we can tell you why.
But why
And we did tell you why.
Right, but why can't you, I mean, why can't you?
But how is that like reversible error?
Because it prejudiced the defendant to the point where he could not, through his expert, present that aspect of his defense, which is, given a lot of the other evidence in this case, critical.
Why is it critical?
'Cause-
Wasn't there a lot of other evidence that he confessed?
Well, yes, if you want to, and that's all, I mean, yes. Inmates,
This is the best he could do. It's the
Well,
best evidence that he had.
I would argue, was the best the Commonwealth can do to put on fellow inmates who say the guy confessed. And we see this all the time.
Wasn't it
where
his
someone goes to
brother?
take a shower and they read your reports. And
His brother was one of the people he confessed to, wasn't he?
yes, although, from a favorable reading of the cross-examination, it looks like his brother, for a lack of a better word, was squeezed by the police. And his brother came with a lot of baggage. None of these witnesses were tremendous witnesses. And then the rest of the evidence, albeit permissible, was very circumstantial. I credit the police for doing a good job in terms of hustling to find out who owned the white acclaim and going out and finding the gun. But regardless, I believe that the strength of the defense was limited, if not completely taken away. And, by the way, unnecessarily. There's no reason that the judge shouldn't have let that come in. It's not as if she didn't believe that the foundation was there or that Mr. Garneau lacked the expertise.
Could I come back to the prejudice question? Are you saying that, that because the judge did not allow this, if the judge had allowed it, let me put it the other way, you are saying that that would have made a difference to the weight of the evidence in this case? I mean, when you put that against all of the other evidence that was out there, the car, the confession, what difference did that make, really?
Well, one of the problems is you really don't know. But I mean, if that's the strength of the defense here, you shouldn't be restricted from offering it. I mean, you get a lot of acquittals at some time when maybe some people who are reading a transcript are scratching their head, but you try in this case, you put on your defense, and if it should be permitted, it should be permitted, and you may win on that. I mean, if you're asking me, like, how can I show we would have won on that? I can't really do that.
No. I'm just trying to figure out the prejudice issue. You know, even if it was error, okay, we're taking your word for it that it was wrong to exclude this, and I'm trying to figure out what difference it made.
Because that was his defense. It wasn't me. I didn't do this, and your best evidence is a videotape, and I'm telling you, it's not, and here's why. And I think that was a good strategy.
Now, refresh my memory. Was his face shown in any way on that videotape?
There was a disguise, not identifiable. I don't think it was identified by any witnesses. I hope.
So other than the height extrapolation, there was no other way to kind of make this person be the defendant, is that?
There were some other circumstantial things like the backpack and things like that, and things that the Commonwealth ultimately linked to Mr. Corliss's habits or traits or things like that, but nothing more than that. I know we're running out of time. Maybe I could just touch on the first issue in my brief, that being the restriction, the Morganti issue, I guess I'll call it. And one of the things that is a little bit troubling here is, I think it's on September 9th, Justice Kottmeyer starts discussing the impracticalities or the undoability of a separate view for Mr. Corliss. And she talks about another murder case going on in the building and a shortage of court officers. That was something that she said it was never really quantified in any particular way, but that's on the 9th. On the 12th, we come back to that, and nothing was ever followed up on.
The problem I have with your Morganti analysis is that in Morganti, it was more than just a view. It was not merely to see the car. They put a mannequin in the car, and they put a yellow rod through the mannequin's head, which was intended to demonstrate that the path of the bullet came from the rear passenger seat or the rear driver's seat. That's what the jury was seeing in Morganti, not just the car. They were seeing this mannequin with this rod saying, this shows you that the bullet came from the driver rear seat where Mr. Morganti was seated. I mean, isn't that really a very different kind of view than the one here?
Well, I guess you could make that argument, but I think Justice Kottmeyer was struggling with this too. And if you read her comments on footnote 9 in Morganti, I tell you what, they started to confuse me a little bit, and that I keep reading footnote 9, and I'm trying to find out what she had struggled with, but I certainly, I'm going to take it and run with it. I mean, and the only thing I can assume was that she viewed whatever was going on inside the store relative to that view as tantamount to a demonstration. And Mr. Corliss was not permitted to see that.
Right, but I gather there was no demonstration done at the view.
Not in that context. I mean, in terms of what's being pointed out or what you're looking at. And I guess the struggle here is what's meant by demonstration in footnote 9 of Morganti. Is it actually the conventional demonstration, or is it more or less showing someone something that cannot be visualized short of actually going out and seeing it? You can't reproduce it in the courtroom in the context that you're showing. And Justice Kottmeyer said, yeah, that's the one thing that seems to warrant a view more than anything else.
Okay, thank you.
Thanks.
Good afternoon. May it please the Court, Mindy Klenoff for the Commonwealth, and with me is Patrick Hagan, the trial ADA. If I could begin with the height analysis, there were a few issues I just wanted to clarify. I believe both Justice Link and Justice Hines asked questions about whether there was other information that would identify the defendant in particular from the videotape, the surveillance. The perpetrator had a scarf over most of his face for most of the incident, but at times it would drop, and you could see the nose and eyes of the perpetrator. And those were distinctive and distinctively similar to the defendant, which was argued if you review the prosecutor's closing argument. He showed side-by-side photographs of the perpetrator in the still with the scarf coming down a little bit, as well as the defendant, and argued that he was in fact identifiable from that. So that's one issue. As to the excluded videotape, just to get the height straight, the videotape essentially gave 3 estimates for the defendant's, well, for the perpetrator's height. 2 were 5'5" and 1 was 5'9". The 5'11", I believe, comes from the defense attorney's opening argument, in which he stated that it was his representation that the defendant was 5'5", and that the evidence would show that the perpetrator was 5'11", including the hat and the wig. And so I believe that that's where those came from. There was no evidence proffered by the Commonwealth as to the height analysis. There was no expert testimony proffered by the Commonwealth. There was no argument made by the Commonwealth as to what the height of the defendant was, what the height of the perpetrator was. It wasn't raised in the opening. It just wasn't raised. The Commonwealth did bring out the height of the bolt on the door just for a point of reference, but never argued it, never went farther than allowing the jurors to come to their own conclusions based on their review of the tape. The defendant proffered the videotape, and the judge found that it was A, misleading, and B, that it lacked foundation, specifically as to the renovated ceiling and the renovated floor. And in addition, there was substantial evidence of other changes as to the renovations. The fixtures attaching the cameras, whether they were at a different height, changing the analysis. The surveillance system itself was different, which it captured a larger physical area, and so the images had to be kind of modified in order to lay them over the other images. And The cameras themselves were actually different. The camera in question was rotated into a different position. So there was a substantial amount of information that the circumstances when the expert went to film the store again were not substantially similar, and so that a proper foundation wasn't laid. If there are no other questions on that issue.
But are you saying not substantially similar because of the alterations to the store, or because of the way that the expert did it?
The alterations to the store, that the physical plant was so different in ways that weren't even measured.
That it was apples and oranges?
Yes, yes. He stated in his testimony that he didn't know whether the ceiling had changed. The judge observed in her findings that the ceiling appeared to have changed based on the photographs, so there's no indication of how much that is. So there was a mass of evidence that there were sufficient changes so as to cause the evidence to lack a foundation. If there are no other questions on that issue, I'd rest on my brief as to that issue. As to the view, the defendant is not constitutionally entitled to a view. There are many, many cases on point. As the court stated, Morganti itself, which involved more of a demonstration than in this case, also found that the defendant was not entitled to go on that view. In this case, the defendant did attend the view, just in a limited fashion, which was appropriate given the very, very serious and well-documented security concerns.
And what was the demonstration here?
There was no demonstration here. The judge actually specifically instructed the attorneys prior to the view that they were not to do any more than point out things to the jury, and there's no indication at all in the view transcript that anything more than pointing out occurred. If there are no other questions, Commonwealth would rest on its brief.
Thank you, counsel.
Thank you.